What is burden of proof? Explain the law relating to burden of proof. The burden of proof refers to the responsibility of substantiating statements with evidence. The term burden of proof is not explicitly defined in the evidence law, but it encompasses the principle of onus probandi, the duty to prove, and the factum probans, the fact to be proved. It refers to the legal requirement or responsibility of parties to establish facts that assist the court in reaching a decision in their favor. As a general principle, the presumption of innocence lies with the accused unless otherwise proved. For example, in criminal cases, the prosecutor bears the burden of proving the defendant's guilt beyond reasonable doubt. In civil cases, plaintiffs are responsible for presenting evidence to support their claims. Provision regarding burden of proof are provided in Chapter 7 of the Indian Evidence Act. Section 101 of the Act provide whoever desires any court to give judgment as to any legal right or liability dependent upon the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So, burden of proof means in the sense of proving the case, and for this purpose, duty to prove all facts necessary for taking the judgment of court. Section 101 has to be read along with Section 102 of Evidence Act, which provide that burden of proof in any suit or proceeding lies on that person who will fail if no evidence at all were given on either side. So section 101 of Act says about the burden of proof in the sense of proving a case and provide whoever wishes the court to give judgment in his favor for any legal right or liability dependent on existence of some facts. Law lies onus on him to prove that those facts exist. Burden of proof in the sense of proving case as contemplated in section 101 in is constant one and never shifts. Section 102 of Act does not provide a different rule. It simply looks from different angle on same rule and says about burden of adducing evidence. Section 102 says burden of adducing evidence rests upon party who would fail if no evidence at all or no more evidence were adduced either party. So, Section 101 of Act provide regarding burden of proof in the sense of proving the case, that is, onus probandi, and Section 102 provide burden of proof in the sense of adducing evidence. If A files a suit in the court against B on the ground that plot of land which is in B's possession belongs to him, A, and B is in unlawful possession. Now, A wants the court to give judgment that B is in unlawful possession of suit land and A is lawful owner of this land. Now, if A desires this decision, he is bound to prove all facts as asserted by him. It means he has to prove his case that he is lawful owner of suit land and that B is in unlawful possession. This is burden of proof in sense of proving case as provided under section 101. If supposing A does not prove those facts or does not lead any evidence, then naturally for want evidence he will fail. So he is under burden to adduce evidence. If supposing A proves his case, then duty to lead evidence shifts to B to present any disproof evidence to the claim of A. If B will not lead any evidence, and then naturally B will fail. Thus, burden of adducing evidence keeps on shifting from one part to another party. Burden of proof in the sense of proving case never shifts. It remains on plaintiff in civil proceedings and on prosecution in criminal proceedings. And then section 103 of Evidence Act provides the burden of proof as to any fact lies on that person who wishes the court to believe in its existence unless it is provided by any law that proof of the fact shall lie on any particular person. Section 103 substantially says similarly what section 101 of Act provide. Only difference is that section 103 is confined to proof of particular fact, whereas section 101 provide for proving who case or all facts are asserted. Section 105 of Indian Evidence Act provides for a general rule in criminal proceeding that burden of proving the offence against the accused lies on prosecution and it has to prove all ingredients of offence alleged beyond reasonable doubt. Section 105 of Act lays down important qualification to rule that everything essential to establishment of charge against accused lies upon the prosecution and Section 105 provide that whenever any accused of an offence wishes to take advantage of any general exception of Indian Penal Code or other special exception or provision of IPC or any other law defining the offence, then burden of proving existence of circumstances bring the case in such exception lies on accused, and court shall presume the absence of such circumstance. In Vijay Singh versus State of Uttar Pradesh, AIR 1990 SC 1459, it was observed that if the prosecution has discharged its duty to prove the guilt of accused, may raise the plea of exception either by pleading the same specially or by relying on probability. He may adduce evidence in support of his plea directly or may rely on the prosecution case itself.